argument first this morning, number 98-727, Teresa Cunningham versus Hamilton County, Ohio. Mr. Goldstein.
Mr. Chief Justice, and may it please the Court, the district court in this case sanctioned petitioner, who is not a party to the underlying litigation, but instead was the plaintiff's counsel. The question presented to this Court is at what time petitioner should appeal the sanction. The Sixth Circuit recognized that there were three possible answers to that question. The first, and this is the rule that the Sixth Circuit adopted, is that petitioner should wait until the final judgment in the case. That rule, however, has some serious problems. First and foremost, it conflicts with this Court's repeated holding for more than 100 years that only parties may appeal the final judgment.
Well, I'm sort of perplexed. Why is it that an attorney would not be a party for purposes of appealing immediately? I would be a party, treated like a party for purposes of appealing immediately, but would not be a party for purposes of appearing at the end of the case. I don't see why conceptually that makes any sense.
It requires this Court to track Rule 3 of the Federal Rules of Appellate Procedure, and that rule instructs that you may appeal from an order or a judgment to which you are a party. No one contests that the petitioner is a party to the sanction order. It is directed at her. She is not, however, a party to the final judgment with which she has nothing to do.
Well, so you're saying she could appeal on the basis of the order but she couldn't appeal from the final judgment? That seems a very strange result.
Mr. Chief Justice, this Court has been quite clear that the final judgment itself has to be looked at in isolation, and you determine whether or not the appellant is a party to the final judgment.
But she's not appealing the final judgment. The final judgment is simply what we refer to determine when she may appeal. She's still appealing the order, whether she appeals it immediately or later.
That is correct.
Is there any reason, assuming that the language is open to your interpretation or the other, which I'll assume for the moment, is there any good reason why we should make this so complicated? Isn't the simple — courts of appeals have a lot to do. And if we take the other position, we're sure they're not going to get into this business of trying to mix is it part of the merits, isn't it part of the merits, etc. It's a single rule for everybody, and is any harm done?
There is no harm in a clear single rule.
Or the clear single rule would be you'd lose, because the clear single rule would be everybody, if you're sanctioned, the time to appeal the sanction order, just like an attorney who's still in the case. The attorney who isn't appeals it at the end of the case. And if you don't like the order in the meantime, ask for a stay. And if he won't give you a stay, go under Rule 8, get the Court of Appeals to do it.
Mr. Goldstein, when Justice Breyer asked you, you could read it one way, you could read it the other way, why shouldn't the tiebreaker be 1292E? When Congress said, courts, this is the kind of thing you want to sort out by rulemaking. You want to make more things final? Court, you can do that through the rulemaking process. Given that signal from Congress, why should we do anything by adjudication to add to the list of interlocutory orders that are immediately appealable?
We have no objection if the Court were to, in addition, use its rulemaking authority to resolve these conflicts, but the Court does have before it this case.
What is the you're being very picky about, Rule 4, Rule 8, and so forth. What is the textual authority for any interlocutory appeal?
The textual authority does lie squarely within 28 U.S.C. 1291. This is literally and figuratively a final decision, and the Court has made clear that it is a practical construction of the term final decision. And
well, if it's just a matter of practicality, we're making it up under Cohen, essentially. We say some things are final decisions and other things aren't final decisions. And we feel free to use the Cohen factors, some of which have very little to do with finality. They have to do with practicality. So why not take those same practical considerations into account in the present instance?
We believe that the practical considerations do favor petitioner in this case. In particular, there is the grave concern that she could not appeal from the final judgment, but that cannot be the right
Why
result.
didn't she try? one of the striking things about the facts of this case is that no protective appeal was taken once there was a final judgment. That was just allowed to happen.
That's correct.
Well, what did she have to lose? Because it seems that would put her in the best position.
That is not correct, respectfully. Under Rule 38, if she files an improper notice of appeal, she can get herself in more trouble. But I do want to pick up...
Where? What kind of trouble?
For filing an improper notice of appeal from the final...
You are envisioning that the Court of Appeals, when someone is in this bind, so the law is uncertain, so I filed a notice of appeal at the interlocutory stage, I filed one at the end of the line. A Court of Appeals would sanction a lawyer for doing that?
It is a concern.
Mr. Goldstein, you have 4 minutes left. What case do you rely on from this Court that holds a sanction against an attorney, contempt, is appealable?
The Hickman example that Justice Ginsburg...
Did the Court discuss the appealability at all in Hickman?
No, Mr. Chief Justice, and the Court is very clear that there aren't implicit jurisdictional holdings. We do not claim that this Court's decision in this case is predetermined by Hickman.
Because Hickman didn't say a word about jurisdiction.
I believe that
it was an opinion by Justice Murphy. So,
did the Third Circuit say something about jurisdiction?
Justice Ginsburg, I believe we're beyond my familiarity with Hickman and Taylor.
Well, there are a lot of cases that have held that if a lawyer is held in contempt for failure to comply with a court order, it's immediately appealable.
We have not seen contrary authority.
That's what I was asking you, Mr. Goldstein. Is there a case from this Court holding what Justice Stevens apparently thinks there is?
The answer is yes, but I can't give it to you today.
Imagine that as an exam answer.
I want to pick up, however, if I could, on the sort of parade of horribles we got from the respondent. We submit that this has been the rule in a number of circuits for 2 decades. The contempt rule has been here for more than 100 years, and this, as a practical matter, has not happened. The Ninth Circuit...
If you say the contempt rule has been here for more than 100, you must know some case. The opinion of the Court number 98-727, Cunningham versus Hamilton County, Ohio, will be announced by Justice Thomas.
This case comes to us on a writ of certiorari to the United States Court of Appeals for the Sixth Circuit. It involves a question of what happens when an attorney is sanctioned during discovery for misconduct during discovery. Can that attorney appeal that even though the case continues on? In an opinion filed with the clerk today, we affirm. We hold today that a Rule 37A sanction order does not qualify as a collateral order and thus is not the final decision under Section 1291. The opinion of the Court is unanimous.